Peter.
Hi.
Hi. So I can't even remember when we met. It was so long ago, very long ago. But
Yeah, I don't like to be reminded of things like that. It was in a different world, wasn't it?
it was it was in a different world. And you are my go-to person of choice when it comes to dealing with things that I don't understand too much about, such as intellectual property. In fact, I think you actually wrote a dictionary about it, didn't you? Some sort of Bible.
Yes, and you very kindly helped me promote it, which was good. And and contrary to my expectations, I didn't get rich.
I know. I tried though. I did.
Well, you did your best, but legal publishing is not something to get rich doing.
No. So, what is people talk about IP, and I've mentioned the words IP to people before, and they look at me, and glaze over and just say, What is it? What does it stand for? What is it about?"
Yeah, well, most lawyers glaze over when they hear the expression as well, um, which which I like a lot. I don't like other people to know too much about what I know. Um, there's a lot of mystique surrounding intellectual property, and I think that's the first thing that you've got to understand, that uh, there's almost as much urban myth as there is law, and that's not a very healthy state of affairs. Lots and lots of people think they know about intellectual property, and actually, well, certainly from my perspective, they don't. But then again, you can define it whichever in many different ways. From my perspective, it's really about the law, and from other people's perspective, I mean, a lot of businesses owe their value entirely to the fact that they own intellectual property, and it's not necessarily something you can pin down and attach to a piece of legislation. It's a slightly wider concept than that, uh, but at heart, the important thing is what you can protect by law. And any form of property that you can't protect through the courts
Mm.
isn't worth having, really. If
So,
you have to go to court to protect it, it's hardly worth having because that's so bloody expensive. But on the other hand, if it's the only way to do it, you've got to be prepared to sometimes.
what does it cover? I mean, I'm thinking about people when they start a new business. So they've got things like their website, they've got their social media channels, they've got a company name. Some people may be using their own name. What sort of things are covered, and what sort of things are there some things that are just automatically covered, and are there some things for which you need to spend some money? How does it work exactly?
Well, as soon as you start running a business, you start acquiring assets which you can protect, which are intangible assets. And I think it's sometimes more useful just to consider these as intangible assets rather than getting hung up about what intellectual property means. So the goodwill of the business is of crucial importance. That's I think probably an accountant would tell you that the goodwill of the business is the difference between the value of the physical assets and the value of the business as a whole. So there is something intangible there that you can't really put your finger on, but it's got a value. And if you're running a good business, you've got lots of satisfied customers, they keep coming back to you, then you've got a lot of goodwill.
Mm-hmm.
That's quite simple. But the goodwill is recognized in the marketplace by being attached to your name. And that could be the company name, and you acquire a company name just by incorporating a company at Companies House. That's something you can do very easily. It doesn't really give you a great deal of protection for the name because somebody can go and incorporate a company with almost exactly the same name the following day. And that's not a very happy state of affairs. In the last 10 years or so, legislation has been put in place that deals with conflicts between company names. So if there is a problem there is a simple way of dealing with it by under the company's names adjudication procedures. But it still only deals with a small problem. And your bigger problem is that by trading under a similar name, somebody else might be attracting your customers away from you. The way to deal with that is to register a trademark.
And is that difficult?
It's sometimes it's unnecessarily difficult, perhaps, but often it's fairly simple. And it's something that most people should be able to do reasonably well for themselves. And actually the Intellectual Property Office, which runs all this in the UK, has simplified the process, and actually simplified it to such a degree that I get very frustrated with it, because it's sort of almost joining the dots, and they shouldn't. It's not really necessary for somebody who's been doing it for years to be sort of led by the nose through the process. But anyway, it's fairly user friendly if you want to do it yourself. But a lawyer shouldn't charge you a great deal for it if you need help.
Yeah, I mean, I've done it myself, and I suppose the bit that I always struggle with is this idea of classification, which is actually how you define your business, right? Whether it's a real estate company, or whether it's a letting agency, or whether it's some sort of weird amalgamation of something and something, and then you can't quite put your finger on it. And then, of course, what always freaks me out is, when you type in the name of something and you find someone with the exact same name, and you think, oh, I really was loving that name, and I really want to cling on to it. But of course, it's okay to cling on to it if someone has classified it for a completely different purpose. Is that right?
Of course, yes. The trademark system's designed to recognize that, that nobody's going to get confused between a Volkswagen Polo motor car and a Ralph Lauren Polo shirt and a packet of Polo mints. So there's plenty of room in the trademark system for people to register identical trademarks, even for completely dissimilar goods or services. However, the way that big trademark owners operate these days is to try and grab as wide protection as they can get away with. And there's been a big problem with foreclosure of trademarks and the using up the stock, because there is only a finite stock. It's still pretty large, but you can't go on forever coining new trademarks, and it becomes more and more difficult for small businesses to get in. And then they find that they've got an argument with some behemoth with very, very deep pockets that they can't possibly contemplate fighting. And the problem very often is that the person who set up a business thinks about protecting the name after they've got into trouble about it, or at least after they've got on the marketplace, they're committed to the name, then they find that they're going to have problems with it, and it can get very expensive and complicated to unscramble that. So it's certainly prudent to have a look and see what other people have got registered, and see whether anybody's got not just identical trademarks, but similar trademarks for similar goods and services. Now, similar is obviously a very elastic concept, and that's unfortunately when you've got to go and talk to a lawyer about it and try and work out what's going on. But unless you've got something that is absolutely unique and so far removed from what anybody has ever done before, in which case, good luck to you. That's brilliant.
I suppose also, as you say, there's this thing called passing off. I'm familiar with passing off, which is when someone sort of pretends to be, you by registering something very similar or doing something very similar, and then maybe doing a few little dodgy things like pointing their website, a similar name at their website rather than your website, and all sorts of things. So what do you think the steps that a business should take before, even when somebody's just got an idea and they're just thinking to themselves, yeah, I'm kind of committed to this name. I've thought of this name. I like it. I've tested it with some people. They seem to like it. What are the steps that they need to take to ensure that they don't run into this problem, as you say, when they've already got down the road and then they're emotionally sort of connected to something which potentially could prove to be problematic for them before they even get started?
Well, I think you can get a long way just by using a search engine. to see whether anybody's got the same name for a business, and you can work out what might be regarded as similar, up to a point at any rate. What you think is similar is not necessarily going to be the same as what the other people think is similar, but at least you make some progress. You can look at what's on the trademarks register. That's publicly available on the Intellectual Property Office's website, and that's certainly worth doing. And if you need to, you can pay somebody who knows what they're doing to carry out a search for you. There are search agencies, and there are online databases which people like me use to carry out searches to find out what's already there, and to work out whether a trademark's available and whether it's registrable. So there are steps you can take to protect your situation. It depends to some extent on how broad your ambition is. If you want to be trading worldwide, then obviously that's a very different equation from if you just want to sell goods to people in your town or village.
And I was just thinking, one of the things that I tell people, because I think especially in the early days, when people have a new idea, sometimes they don't want to share it with anyone because they think that someone's going to steal it, you know. And my experience is that people almost never do, because to actually set up in business and to actually go through all the steps, find the customers, do the marketing, figure out all the stuff, build the website, it's not that easy. And people do generally want to support somebody and help them in a new business. But then on the other hand, I recall an incident where when I was selling a baby sling very many years ago, obviously, because I don't have babies anymore, I used to go to baby fairs, and there was a woman there who did this cup called the Anyway Up Cup. And it had a semicircular bottom on it. And she was just a woman with a kid, and she used to go to these baby fairs and take a little stand just like me. And she used to sell this cup, and it always sold out because it was so clever and it never tipped over. It was just genius, right? But I recall that she did patent it, and there was quite a big court case. I think it was a baby manufacturer that tried to replicate it.
It was a company called Jackal.
Was that who it was?
Who was the defendant in the patent action? A great name.
But, you know, are there circumstances where, would you agree with what I say? I mean, just generally, and do you think there are circumstances where it's actually really important to go through the process of trying to get a patent, and how long does it take, and all of that? I realize this is so elastic. It's probably, you know, varies enormously.
Yeah. Okay. Well, you're getting ahead of me, but that's great. You've got some very good questions here. Before I talk about that, can I just go back to what you were saying about passing off?
Yeah.
In a sense, passing off is a way of protecting a trademark that you haven't got a registration for. But in another sense, passing off is about protecting your business's goodwill. So if you've got goodwill or a trade reputation and somebody's taking advantage of it in some way, then passing off is a way to protect it. But it's a very expensive way of protecting it. And instead of turning up in court with witnesses who will go in the witness box and tell the judge that they're confused about having, well, in the classic case, 2 different plastic lemons full of lemon juice on the supermarket shelf. I think they had about 100 witnesses in that case, and it was in court for 2 weeks. Now you can just begin to imagine how much that might have cost.
Wow.
You don't want to be doing that. You want to turn up in court with a trademark registration certificate and say, look, this is my property, Mr. Judge. Tell these people to stop. That makes it much easier and therefore cheaper, of course. And you can get into court these days quite cheaply with intellectual property disputes, because there's a court called the Intellectual Property Enterprise Court. I think there's an act of parliament somewhere which says you must slip the word enterprise into the title of everything you set up, if you possibly can. Anyway, the Intellectual Property Enterprise Court used to be called the Patents County Court. And the fact that it was a county court tells you that it's a sort of cheap and cheerful jurisdiction. And in fact, they have a palm tree at the front of the court that the judge sits under. Well, at least I noticed it when I was there, but just maybe other people didn't.
Like your beach. Bit like your beach there. Or mine. Mine's actually a banner though. See?
Oh right. No, this was a Southern Ocean, so it's very, very cold. This, but it's a beautiful blue. So yes, so it's possible to get your disputes into court relatively cheaply these days, and to get pretty effective justice actually, and not to have the wool pulled over your eyes or the judge's eyes by defendants with deep pockets. It's quick and pretty effective.
I didn't know that.
So that's worth bearing in mind. But if you go to that court with a passing off case, the judge is likely to say, you're going to need far more witnesses than I can possibly accommodate, because I'm really limited to 2 days for a case in this court. And if you want 100 witnesses, then this isn't the right place. Off to the High Court with you, and you pay 100 times as much. Passing off is not really a solution.
Yeah.
But it is there as a what classically educated lawyers would call tabula in naufragio, a plank in a shipwreck. So that brings me on, that little digression brings me back to patents. Mandy Haberman and the Anywhere Up Cup. Mandy Haberman is a great evangelist for the patent system, and it's certainly worked very well for her. But in order to get a patent for something, you've basically got to have something like the Anywhere Up Cup. It doesn't have to be a tangible product, but if you're trying to protect computer code, that's not the way to do it. If you're trying to protect the method of doing business, the patent system isn't really the way to do it. There are ways of getting in there, but you could spend a great deal of money and end up with a patent that really isn't going to give you very much protection. Because a clever patent attorney will be able to draft a patent specification that'll satisfy the examiner and no doubt satisfy the patent attorney's bank manager as well, but will end up giving the client something that's so narrow the client's going to think, why on earth did I bother with that?
I suppose the fashion industry is the most obvious place where people have tried to protect designs and all sorts of things, and then there's just been slight tweaks to those designs, which has basically ruled their patent or whatever they had, whatever their design rights were, kind of meaningless.
Well, patents themselves are concerned with technical effects. So you've got to have something doing something technical, rather than just something that looks nice. If it looks nice, then you can get a registered design. In the United States, they call that a design patent, in fact, or a design patent. So a bit of confusion arises there. But in this country, it would be a registered design. You also get automatic protection for designs as well as soon as you make one. But that protection lasts really only for 10 years from when you put articles on the market. So a patent could be extremely useful if you're in the right area. If you've got something like the Anywhere Up Cup, then it's well worth considering getting a patent. It could cost a great deal of money if you're going to protect it throughout the world, because you've got probably 200 countries which will grant you a patent if you ask them. You don't need them all, and in fact, big patent owners don't even bother with all the countries in Europe, because they know that if they've got France and Germany and Poland and the UK and a few other big ones, then nobody's going to bother ripping them off if all they can do is sell their rip-off product in Estonia. Not that I've got anything against Estonia, that sounds terrible, but if it's too small a market to support the effort, then they won't bother if all the big markets are already taken up.
I think Estonia is the only place where we can get an EU passport now, isn't it? So we might find loads of people going to Estonia. Probably not a great example, but yeah, no, I take your point. I mean, all I know about patents is that you do have to generally have deep pockets, and that it can take quite a while. And that, as you say, especially around software, there are things that I think actually somebody told me that Tinder has protected the swipe, that they actually have a patent for that swiping motion, and Amazon have a patent for the buy now button, I think.
The one click.
The one click. That's
Yeah.
yeah.
They got that years ago. And the American patent system is very different from the European system. And we do still have a European system of which the UK forms part, because it's nothing to do with the European Union. So you can get patents in the United States for things that simply wouldn't be patentable in the EU at all.
Oh, right.
Or in Europe. And I think I'm right in saying that Amazon's one-click patent, which is now so old it's probably expired anyway, is one of those, because it's simply a business method.
Yeah, exactly. So in terms of things like social media, I mean, people now are making businesses out of their Instagram channel. You know, they're getting millions of followers, and I think of all the social media channels, that's the one I think to myself the most. How protected are they in that circumstance where actually Instagram is really the owner of their channel, and they merely have a page, as it were, on it? What can they do in that situation? Do they have any protection at all?
Well, Instagram is very much based on photographs, isn't it?
Yeah.
And if you're publishing your own photographs anywhere on the internet, you've got copyright protection. Of course, the value of that copyright protection is pretty limited once you launch the photograph onto the internet, and you can use all kinds of technical means to try and prevent people from copying it and tracing it if people do make copies. But ultimately, all that gives you is the right to haul somebody before the court and claim damages from them. And that's a great deal of trouble, and it's not guaranteed to succeed. So copyright is at the heart of what people put on the internet. And copyright has the great advantage that it arises automatically. You don't need to register it, or you don't need to pay any application fees to anybody. It's just there. As soon as you take a photograph that's your original work, as soon as you write something that's your original work, then there's the copyright. But of course, equally, you want to use things that other people have created and in which they own copyright, and then you get into slightly difficult territory. Unless, however, if you're careful, it's very difficult. If you're careless, it becomes very easy, because you can rip off people so easily using internet technology. But it's not a very clever way to proceed, and it could well land you in trouble. You're unlikely to get into trouble if you by pinching a photograph that I've used as a background on my Zoom or anything like that. I don't own a copyright in it, but I'm unlikely to come after you. But if you find that you've used a photograph that Corbis or something like that owns the copyright in, then God, you're going to feel the heat.
And what about when people say there wasn't, I don't know if it's an urban myth or it's true, that I used to hear years ago, that people would say, when you write something, put it in an envelope and date stamp it or something, and then put it in the post and send it back to yourself, and don't open the envelope. Do you remember that?
Yep.
Is any of that true?
That can be quite effective.
Yeah.
It's effective if you've created something and you're worried that somebody might accuse you of having copied it from them.
Yeah.
But of course, it's only effective to the extent that it shows that you had created that at a particular date, and therefore you're showing that the person who's accusing you of infringing came second in time. It doesn't cover any other situations. It doesn't prove the originality of what you created or anything like that. But so up to a point, it's quite useful. And in fact, American lawyers refer to this as poor man's copyright, because in America, they do have a registration system. So instead of what you're doing there is, instead of going through the registration system and paying your not very substantial fee to the Copyright Office, you're short-circuiting that and doing it for the price of a postage stamp. Probably better not to send it to yourself, but to put it in a sealed envelope and give it to a lawyer or a bank or something like that, because there's always going to be a little bit of suspicion hanging around if it's always been under your control. But it's a perfectly valid technique. It's just not going to solve every problem, but it'll solve some.
And how about in cases where somebody, I'm thinking about craftspeople, particularly people that make jewelry or clothes or some other craft. Is it worth them doing anything? Is there anything that they should consider in terms of trademarks or any design rights, as you said, any sort of other protection? Is it worth in those early days thinking about any of this, or is it just an additional kind of like, thing that you can kind of park for a little while? I'm always thinking at the beginning of like, what is it that people need to know right at the very beginning of starting a business that can avoid them getting into a sticky situation later on? We talked about the name and about, doing those Google searches and the searches with the IPO to make sure that you're not taking a name that's been used for the same purpose. But in the case of somebody, there's a lot of people at the moment designing masks, right? My friends are all designing masks and selling them, African prints, designer prints, whatever, designery masks. Is there any point to any of what should they think about, and what should they think? Well, it's probably, you're unlikely to run into any sort of situation here.
Well, I think every business needs to consider protecting its name and, by extension, its goodwill, possibly by registering a trademark. But in order to get a registered trademark, you've got to have something distinctive, and that can be quite a hurdle to get over, especially since very often the first instinct of people setting up a business, or certainly the marketing people if they're involved, is to think of a name that's pretty descriptive.
Yeah.
Which is the enemy of getting trademark registration. So that's a starting point. Coin an interesting and catchy name for your business. Use your own name by all means, but be aware of the fact that if you're called Smith, that's going to make trademark registration a little difficult.
Or in Mark's case, who's my colleague, he bakes bread. If he was just thinking of calling his company Bread.
Yeah.
I think we went through a situation where I tried to do something which was just like some very, I can't even remember what it was, some very typical word, although I remember that when we registered Frugal years ago, Google at that point had a business called Frugal, which was spelled Froogle, and mine was spelled Frugl. And I recall thinking, maybe we won't get this because, Google owns a word that's pronounced exactly the same. But I think their trademark had just expired, and they didn't contest it. No,
nope.
Contested it.
No, we took the gamble, didn't we? Well, you did. I didn't gamble very much, but the gamble was that Google had lost interest in it.
Yeah, exactly.
But I think that was proved that they'd had it and they'd moved on. They didn't have any further use for it, so they weren't concerned about you.
No, exactly. Although the Australian version is now gone public, and they're still trading with nothing more than an Australian domain name, none of the social media, none of anything, and they're just carrying on. And I recall we were going to contest it, and then I decided it wasn't worth it. And I find that interesting because clearly they're a big business who just decided that actually maybe being in Europe isn't on their roadmap. So they just are like, well, we're just going to remain in Australia. And if somebody's got the trademarks for the rest of the world, that's okay. So I suppose businesses always weigh up how big or small they want to go, whether somebody poses a potential threat or an opportunity, or all of that. all of that gets weighed up, doesn't it, really?
It does. And, you know, well, I've always regarded my job as a lawyer to help clients avoid disputes and arguments and things. Some lawyers seem to take a different attitude. But it would be nice to think that if you want to get into a marketplace and somebody's already got a trademark which looks as if it might be a problem, you can go and have a rational conversation with them.
Yeah.
But I've come across very few trademark owners, if any, who will take that sort of attitude. If they think somebody's interested in even just putting a toe across the border of their protection, they'll suddenly become very, very defensive. Suddenly that will become the most important asset in their intellectual property portfolio, and they'll fight tooth and nail to protect it, which I suppose is not surprising. And it's in a sense, it's my naivety to think that you can go through life avoiding disputes, but it's nice to be able to when possible.
I don't know why you became a lawyer. Seems an anathema, really. A lawyer who avoids disputes. That makes no sense to me.
Being a lawyer is about the law and using the law to help the clients, and that doesn't always mean having arguments and disputes.
Yeah. So anyway, going back. So just at the very beginning, just you know, what are those 5 things that you would say, or your 5 top tips for don't screw this up at the start?
Well, I think first of all, ensure that you keep secret what needs to be kept secret. Mm-hmm. Don't tell too many people. You can talk to your lawyers, you can talk to your bank manager, you can talk to your priest if you find that helpful, because they're all under obligations of confidence to you. Mm-hmm. Otherwise, think about getting a non-disclosure agreement, but that's a bit heavy-handed sometimes.
Yeah.
As we saw with the off-qual episode in the news recently, where they were happy to have expertise from the Royal Statistical Society, but they weren't happy for the experts to talk about what they were doing. So use non-disclosure agreements in some circumstances, but I think more to the point, keep things secret. If you've got something that has a technical effect, whatever that might be, then think about a patent, because a patent really is the strongest form of protection you can get. You might not be able to get the patent that you would like. You might not be able to get any patent at all. But if you've got some sort of technical effect which looks novel, then consider it. You might have something you can protect that way, and talk to a patent attorney about it. And if you find the right person, they might give you a bit of advice, you know, free of charge to start with, and the expectation that there'll be more work later. Protect the reputation of your business by registering a trademark. Don't rely on the fact that you can fall back on the law of passing off, because that's really going to be too expensive and complicated. And be very careful to keep your distance from big trademark owners, in the sense of ensuring there's differentiation between your trademark and theirs, or the goods and services that you're registering for and theirs, because big trademark owners have big institutional shareholders looking over their shoulders, and in a sense the trademark enforcement is out of their hands. They don't take a rational decision about whether they're going to win a trademark case or not. They take a rational decision about whether they're going to get beaten up by their shareholders or not, and that's 2 very different things. Remember that copyright arises automatically and is omnivorous. It protects just about anything you can create, provided that your work's original. It also protects sound recordings and films, which can be quite important, and broadcasts. So you might rely to quite a large extent on copyright, and the fact that it arises automatically and protects you around the world is very useful. But remember also that it's doing the same for everybody else. So be terribly careful about picking up something which is protected by copyright and belongs to somebody else who might not like you using it. And just because it's on the internet doesn't mean you can use it. These days, of course, with things like Creative Commons licensing, you can find all kinds of stuff that you can use, often without restrictions, sometimes with restrictions on commercial use. So be on the lookout for that. You might not be able to do anything you like with commercial, Creative Commons licenses and other similar sort of arrangements, but there's an awful lot of stuff that you can use without too much difficulty.
Yeah, and I suppose the words to look for in those instances, which are the words I always look for, is royalty free, and which means you don't have to pay for their usage. Or, as you say, there's specific circumstances in which you're allowed to use something, whether it's in a specific context, like just on a website, but not in print, or something where something's not going to be sold, etc. But I think there's lots of, as you say, there's lots of, and I've certainly taken advantage of it, places like Unsplash and you know, copyright free music libraries and all sorts of things where you can actually find free resources to spice up your website or whatever it is you're doing without ripping people off that potentially would like to be earning money from their creativity, right?
Yeah, absolutely. And I go further than that, actually, and say that if you find the right image, you might well find that if you pay the owner a $5 or something like that, you can do what you like with it. Yeah. So doesn't the photographer own that? Justify that? Doesn't it justify paying the photographer a bit of money if they've done the work that you wanted doing? You know, £5 or so is not a great deal to pay them, and it'll make them happy. Makes the world go round.
Especially at this particular point in time. Anyway,
I think, and you wanted 5. I think that's 4 points, and the fifth one was to do.
You could do another one if you want.
Well, okay, who's counting? I just wanted to say that if you're producing things, the appearance of which articles, which have important appearance, like jewelry you mentioned, or pottery, or all kinds of things, baby cups even, the appearance might be important. Then you can get protection for them by registering a design. That's not very expensive, but your design has got to be novel and it's got to have individual character. And these days, so much design work sort of harks back to an earlier age. There's a lot of retro. I mean, if you've got retro elements in your design, it's probably not going to work for you. But if you've got something which meets that requirement for novelty, then registering the design is probably pretty useful.
And just as an example, how much does it cost to do that? I know a trademark, if you do it yourself, I think is around £170 or something. I think that was the last time I did that myself.
That's right. It's 170 for one UK trademark in one class.
Yeah. As a word. And also the thing that I did was just, sometimes people just think about a trademark being like a logo, but actually it could just be a word. And I've just registered just a word. And, but I've never, no, I did register my design, my baby sling design as many years ago. So yeah, I can't remember how much that cost though, actually.
I think in the order of £60 these days.
Oh, right. So it's quite reasonable. Yeah. I can't remember.
So that's not expensive. It's well worth doing. So, you know, it might not work out in the end. It might not give you the protection you want, but at least you haven't lost a lot of money. Whereas if you've got a patent throughout the world, that's going to cost you tens of thousands of pounds.
Yeah, and I think the other thing, of course, about it is that, as you say, there's no guarantee that once you've spent that £60 or that £170, if it turns out that it gets rejected, you lose that money. Like it's gone. So you can't go, oh, can I have it back now? Because it didn't, I didn't realize it didn't fit into that, or I didn't do my homework. So I think always the best situation is try to be as certain as you can, do your homework before, make sure that you've actually got a good chance of getting that trademark and getting that design right. Otherwise, it can just be a case of just throwing money down the drain. That's
true. I should say with a trademark, you do have the option of paying a slightly higher fee. I think it's 200 rather than 170. But in installments, so you only pay half of it up front, I think, and then if the trademarks registry say you haven't got a hope in hell, you can say, okay, well, let's forget it. I've only lost 100 that way.
Oh, was that true? I didn't know that. Oh, learn something new every day. Thank you. Thank you. That concludes our episode on IP, copyright, trademark, design rights.
We managed to cover it all, didn't we? That was good.
Summed it all up. That was good. Thank you.
Excellent.
And yeah, the check's in the post.
Oh, I look forward to that.
All right.
What's a check?
Who knows? Bye.